Go ahead and call the Senate to order. Sergeant, so please secure the chamber doors. Members, please take your seats. Madam Clerk, please call the roll.
Mr. President.
All right, Senators, we will substitute today's earlier invocation for this evening's. Has everyone recorded, or this afternoon, excuse me. Has everyone recorded their presence? If so, the clerk will take the call. With 41 members in the chamber and a quorum being present, the Senate of Maryland is again back in session. Any introductions? Yes, Senator from Montgomery County.
Thank you, Mr. President. I have two staff members I would like to introduce. The first is Samantha Garay. She is my legislative aide, and it was my honor to sort of poach her from the senator from District 14, where she worked for many, many years. She's originally from Germantown. She now resides in Columbia and graduated in 2020 from the University of Maryland College Park School of Public Policy. So please give Sam a warm Senate welcome.
Welcome back, Sam. Welcome.
Thank you. And then my second introduction is Eli Gendelman. He is my intern for this session, one of my interns. He is a constituent. He's a junior at University of Maryland, Baltimore County, majoring in political science and minoring in law and justice and practical policy. So please
Wonderful.
give Eli a warm Senate welcome.
Welcome, Eli. Welcome, welcome, welcome. Any other introductions? Any other introductions? Nothing? Oh, yes, I'm sorry. Senator from
Mr. President, if I could, I have two of our interns in the gallery on either side. Brianna Garcia, and stand up, ladies, stand up, and Caroline Garrett. They're both College Park students. Brianna is looking to go to University of Michigan for a grad school, and Caroline is a junior, Brianna is a senior. Welcome them, please. Thank you.
Excellent. Welcome, welcome, welcome. Any other introductions or observations? If not, so we could consider the reading of the journal from the prior legislative day. We have a number of bills from the House. This is calendar number 20. Clerk will read the bills.
House Bill 18, Delegate Polakovich-Carr, Vehicle Laws, Noise Abatement Monitoring Systems Pilot Program, Inspection and Extension, Judicial Proceedings. Majority Leader moves so be considered the reading of the bills. They will be referred to their appropriate standing committees. Senators, we're going to have a bit of an interesting, status for this second part of session, or really the last third. There are a lot of House bills that don't have cross files, which is anticipated because we had a big shift with our bill limits and theirs. And so we're going to see how it plays out, take the best we can. And committees are going to do as much as they possibly can, but a lot of these that have had no full bill hearings over here, they're going to have to, learning about them for the first time, and we'll see how many we get to. So we're going to keep trying. We're going to work as hard and as fast as possible, but it's going to be a new feature that we're going to be navigating this year. It's just the impact of our bill limits with the number of non-cross-filed bills. So just keep that in mind as we're going through hearings. There's going to be a lot of hearings on bills that we have not heard. So just think about time as we get into the last 21 days here. All right. Let's see, actually, we do have another one of House bills. Calendar 21. Clerk will read the bills. House Bill 30, Chair, Economic Matters Committee, Limited Line Credit Insurance, Qualifications of Applicants, Finance.
Majority Leader moves so be considered the reading of the bills. They will be referred to their appropriate standing committees. All right, let's go to, we got a special order calendar. Let's see if we have this figured out yet. This is special order calendar number 40, local school construction. Clerk will read the bill.
Senate Bill 843, Senator Hershey, School Construction, Local Cost Share Alterations. Question is on the adoption of the two committee amendments and the favorable report.
Questions on the two committee amendments and the favorable committee report. Recognize the bill sponsor on the amendments.
Thank you, Mr. President. We met in between sessions. We are still trying to work on a solution. Can I special order this again until next session?
Yep. Any objections? Without objection, the bill will be special ordered to the appropriate time at the evening session. All right. We've got a layover bill, calendar number 28. Clerk will read the bill.
Senate Bill 977, Senator Lamb, State and Local Agencies, Enforcement of Federal Immigration Law, Restrictions on Access to Information, Maryland Data Privacy Act. Question is on the adoption of the 2 committee amendments and the favorable report.
Question is on the 2 committee amendments and the favorable committee report. On the amendments, recognizing the minority whip.
Thank you, Mr. President. I've had a chance now to review and look at this bill a little bit more during the layover period, or during the break between the 2 sessions, and I wonder if I could ask the floor leader to yield for some questions.
Will the floor to yield? Senator may proceed.
Thank you. So, for starters, I'm a little curious. This bill, it had several amendments. It deals a lot with personal information, covered records, and data, but it does still have some things in it that I think are somewhat concerning from a perspective of dealing with the federal government. Could I just ask, what is the goal of the bill as amended now? What's the goal? What are we trying to accomplish?
The goal of the bill now is, so there's information that our government agencies hold, and that information is generally subject to the Maryland Public Information Act, the MPIA. And so what happens is that sometimes private data brokers, private companies or entities will file that PIA request for certain information. They'll sweep up that information, they'll package it together, and then they'll sell it to a third party. And so what the goal here is to cabin that information off, essentially say, hey, look, if you're looking for this information from our state agencies and entities, you're just gonna need a judicial warrant if you're gonna use it, if you're requesting it for the purposes of immigration enforcement. We did something very similar to this 2 years ago with the MVA data and law enforcement accessing that database. We just said, hey, look, you've gotta have a judicial warrant if you're gonna go ahead and solicit information and go into our MVA database. You're gonna have a judicial warrant for that. There was also a reporting requirement associated with that bill, as there is here with this bill. And we found that over the course of the implementation period of the bill, or since the bill has become a statute, there's been maybe 1 or 2 inquiries from federal law enforcement officers for that MVA data.
So that's all there's been, is only 1 or 2 in the last 2 years?
That was
The MVA
before
data?
the current administration took office.
I'm not surprised then.
Yeah.
They weren't too interested in enforcing the law before, so, sorry, I strike that from the record. That's editorial commentary about federal politics.
Appreciate that.
So I think the answer you've given me, I'm hoping I can get some clarity on this question then, because the U.S. Code 8-1373 says you cannot forbid local government or state government from communicating and cooperating with Immigration and Naturalization Services, what it was called when the law was passed. Obviously now it's ICE. How do we get around? How is this? Won't this violate federal law? I know you don't have to cooperate, but to say you may not cooperate, doesn't that violate federal law?
Well, you're still cooperating if they have a judicial warrant. And so that cooperation exists under certain conditions. And those conditions, again, we talked about this a little bit with the bill that we had for sensitive locations, the tension between the role of the federal government and obviously federalism and the role of states in the 10th Amendment, and the ability of states that any law, any power that's not specifically enumerated in, let's say, Article 1 is then reserved under the 10th Amendment to the states. And so there's a lot of tension there that this new administration, through its activity, and specifically under the guise of immigration enforcement, is placing on the 10th Amendment and the role of states. A similar law to this is being litigated in New York. And so, to answer your question, I think that's a good question to ask, but no, the state is not cooperating, is not, not to do a double negative, is not cooperating, it's just placing conditions, having that judicial warrant.
Well, it's interesting because as I read number one, what the current presidential administration is doing is simply enforcing detainers, including removal orders for removal. Would an order for removal be a judicial warrant?
That's an administrative warrant, a detainer. So that does not have the same force as a judicial warrant, which has to be issued by a federal judge or a state judge, federal district court judge or a state judge.
That's interesting, because you're telling me that if the federal government, because up until about now, and I don't have the stats in the last couple weeks, but up until late February, 97% of the deportations the federal government had done were people who had had orders from removal under President Biden's administration. So this idea that it's all this is so controversial is not correct, the way it's been reported in the media, that somehow there's, the ICE department under President Trump is crashing through the underbrush and grabbing people and throwing them back over the border. As of I believe it was late February, if I'm being conservative, we'll call it mid-February, nearly 100% of the deportations were ones who'd been slated for deportation under President Biden. Now, that number may have gotten a little less than 97% now, but it's still a vast majority. So we're saying that the detainer for deportation is not going to satisfy the requirements of this bill.
No, that's look, even today, if you went into someone's, private, company, or you tried to get into someone's house, or you tried to get even to a public place, and you only had that that administrative warrant or detainer, that wouldn't be enough for someone to say, hey, look, I've got rights, I've got constitutional rights. This is an administrative thing. Remember, it's issued by a government bureaucrat, not by a judge. And so what this bill says, and what all of the legislation that we've passed this session has said, is, look, we will cooperate, but just have a judge give you a warrant and make sure that it's a valid request, and the state will cooperate.
I know you're aware, but for the body, and I'll ask a question following this, but for the body's knowledge, ICE detainers are not generally put on folks simply because they overstayed a visa or because they, even came across the border illegally or came across the border in a plane illegally. Their ICE detainers generally are for people who've been either convicted of or suspected of quite serious crimes, things like burglaries and robberies, kidnapping, homicide. We've had prominent cases of sexual assault and homicide attributed to gang members from gangs like MS-13 and other gangs, who now have been deported and were waiting for deportation for months or even years. And now a new administration has taken over and said, hey, we're gonna go to town on deporting these very dangerous criminals who are already not here legally in our country to begin with, but have gone to the next step of wreaking havoc in our communities, murdering, raping, and causing all kinds of havoc. I'm at a loss to understand, and Mr. Chairman, I'll ask you, how is it in the Maryland's public's best interest for public safety to not allow for a robust communication when there is an ICE detainer lodged against someone who is already here illegally? How is that in the public safety interest?
Sir, certainly. If it's a matter of public safety, then you're certainly going to get that judicial warrant, which is what we're suggesting here. But second, I would take exception to your characterization that detainers are only issued for folks that are suspected of violent crime or of some of the more heinous crimes that you mentioned. That's not the case. And it's the stated policy of this administration, and I hate to, Mr. President, kind of bring that in, but that's exactly what we're doing here, is that, and this is their language, not mine, is that you start off with the worst first, and then you broaden the aperture to the folks that may have had a detainer on for whatever reason next, and then you broaden the aperture even more and go after all 11 million people who are here without documentation. And so I think that's a pretty clear policy goal and objective of this administration. These are folks that have been here in some cases for decades, paying taxes, working 2-3 jobs. They're a part of the fabric of our community and of our state and contributing mightily. And so what this bill says is, look, if you're going after those violent folks or those folks that are suspected of nefarious crimes, go ahead and do that. We will cooperate. You just got to go ahead and get that judicial warrant, make that judicial determination, just as you would with someone who is a citizen here. So I don't think this is, I will make a more affirmative statement. This is not a roadblock or an inhibitor to public safety. The bills that we have passed with regard to immigration, actually, I would argue enhance public safety, enhance cooperation with the state, enhance cooperation with those who are in this status with law enforcement. That's what we did with the U visa bill. What this bill does, it says, look, if you are suspected of one of those crimes, get that judicial warrant as you would with anyone else, and the state of Maryland will cooperate and help you in solving that crime and holding that individual accountable.
When we say a judicial warrant, is this from a state judge, or would it be from
Could
a
be a
federal
state judge or a federal judge.
Federal judge. How long will it take to get a judicial warrant?
Warrants, look, I know some judges that have the ability to approve a warrant on their iPad, at all hours of the night. So you can get a judicial warrant with relative ease and speed.
Could ICE get a judicial warrant in advance of knowing that such and such person is going to be released is going to finish their sentence at Montgomery County Jail or Howard County Jail or wherever on April 1st? Can they go ahead and get that judicial warrant now?
Certainly, but I mean, you're drifting into another bill, which is, I'm sure we might have that debate a little bit later on, but that deals with the 287G agreement, so that's a different kind of area. But the answer is yes, you could get that judicial warrant.
Well, but what if it's a county? Well, respectfully, if it's a county that doesn't do 287G, and ICE is trying to say, hey, this is somebody who's been in jail for like a serious crime or crimes in general. I mean, forget serious. If they're not here legally, and then they've committed a crime that this required jail time, to me, it almost to me doesn't matter. Obviously, the more serious cases, you certainly want to get them out of the country. But even folks who have violated the public trust to the point where they've robbed somebody or they've stolen a car, the sympathy is wearing thin for most of us in this country and in this state for that kind of behavior. But what if it's a county that doesn't do 287G?
No, so here's the thing. I mean, look, I think everyone in this body agrees with you that if you violate the law, you should be held accountable, regardless of your immigration status. And so what counties are doing, I think only 3, maybe 4 counties are online with the 287G program right now, and 3 or 4 more are coming online toward the end of the month. What this does is say, well, this bill is different than what we're having the argument, but no one in this body would suggest that whoever you are, you should not be held accountable under the law. So I am in full agreement with you there. If you're a jurisdiction that does not have a 287G program, you can still do that, and they are doing that. My county, Montgomery County, cooperates with ICE, and when folks are undocumented and they become justice involved, our county is cooperating with ICE to ensure that person is held accountable under Montgomery County and state law, and then at that point, they will interface with immigration officials. That's happening without a 287G program right now.
Okay, if you don't mind me asking, thank you, Mr. President, how do they interface with it right now? If they've got somebody that has been arrested and served a sentence of, I don't always know all the sentences at the county level, but let's say they've served 9 months in the county jail and they're going to be released. You're saying that counties that don't, and I know a lot of counties don't specifically do 287G. Some of them do a little bit of a hybrid where they cooperate, but they don't necessarily do the exact program. How do they make sure that person is not going to be staying in the country to continue their illegal activity?
The local law enforcement communicates with ICE directly, and you don't have to have a 287G program to do that.
Right.
The 287G program gives you training and some money and resources to do it. Actually, I went up and saw one up in Hartford County. I went out and saw how this whole operation works, and so you just do that. You just don't have, the only things that are absent are the annual training, and you don't have an immigration official inside of your detention center at your local jurisdiction.
Okay, but back to this bill. So what in this bill is going to keep?
Nothing.
This bill doesn't restrict any of that behavior. But if they don't have a judicial warrant, if ICE doesn't have a judicial warrant, they can't.
So
your county can share with them, but they can't ask you, right?
I think your question
Not you. I'm sorry, the royal you. Thank you, Mr. President.
And the royal you. The senator's questions are squinting towards, I think, the initial iteration of the bill. That stuff has been struck out, so there's no physical obstruction. This is all about data. This is about state data, most of which is subject to PIA request anyway. And this is about, for the most part, this has a reporting requirement, as we spoke to, but this bill is about protecting personal data that our government agencies hold, and protecting it from folks that are trying to go ahead, get that information, and sell it for the purposes of immigration enforcement. So the scenario you're talking about in an actual physical, detention center, that's not what this bill is about.
So if you could elaborate on that, because I do think this is important. Sometimes we ask questions because we know the answer. I'm not sure I completely know the answer. I'd like to know a little bit better what this bill does. You're talking about people will take are there people who or groups that troll for data, and then how would they get data and then sell it to the federal government? I don't understand that.
So most of what this will happen is, so we have a PIA, the public information. So a private entity will file a public information request for a swath of information from our state agencies. They will then gather that information, package it up in whichever way they see fit, and sell it. So they're called data brokers. And so that information is very valuable for a multitude of different industries and uses.
Yeah, sure,
Okay.
sure.
And so what this bill says is if you are getting that information, you cannot get it from our government for the purposes of immigration enforcement, and you cannot sell it on the third market, like on the marketplace, or to anyone looking for that information for the purposes of immigration enforcement. So, for instance, the federal government, you couldn't turn around and sell that information to ICE for the purposes of immigration enforcement.
Does that happen now?
I mean, I think that's why it is happening, and it's also impossible to understand the extent to which it's happening because we don't have any sort of data tracking or reporting requirement for that. But that information is being requested all the time, all across the nation.
I guess I wasn't aware that the federal government buys data on potential criminals, basically. I wasn't aware that the federal government buys data.
Again, it's not criminal data.
In that respect.
These are folks that are, paying taxes. It's address data. It's, not specific. It's PII, all sorts of personally identifiable information. And that information is largely not about people that are involved in any sort of nefarious or criminal activity. It's just folks that are here in a different status, right? They're non-citizens. And so the association with criminality is not one that is distinguishable in terms of the data that's being sucked up.
So, yeah, thank you. So what is the federal government buying the information for?
So they could buy, if they're trying to build a profile of folks who are here as non-citizens, that's PII. That's information that's identifiable. So then you can marry that with, well, where's their address? Where's the address of their work? All that type of information can be put together to locate a person at their place of work and or their house and the like.
It's just interesting. I don't understand. Let me ask this other question then, because this is sort of a brave new world that I'm not really all that aware of. That doesn't mean it's not happening. I just have not been aware that the federal government would be buying information on people who they think might be here illegally. Thought, number one, it'd be nice to know that the federal government has plenty of information on people, but of course, if you're undocumented, you're undocumented, so we don't have documents. That's the whole idea.
Well, respectfully, you do have documents because you do file taxes and you do,
Some do.
Yeah.
Some do, yeah.
100,000 IT filers in Maryland.
I had one other question, I think. There was a part of the bill, there's two spots in the bill, I think this was in the bill originally, but it's not been amended out, that talks about deny access, a law enforcement agency or a unit of state government or local government shall deny access to the database to any individual who is or appears to be seeking access for the purpose of enforcing federal immigration law unless they present a valid warrant and clearly identifies the record to be accessed. Can you explain to me what that language means, clearly identifies the record to be accessed?
Just meaning that you have to identify the information that you're seeking with specificity, and so that you're not doing kind of a broad swath of collection of information, but just be more specific in in the nature of the information that you're requesting.
So even if the federal government is saying we'd like information on 2 or 3 categories, or as long as it's specific, it's
just more specific, because a lot of times, this happens even with normal PIA requests for a private individual. If you make an extremely broad request, you're going to get a response that says, "Hey, we need you to narrow this down. What you're requesting is a little bit too much. Can you help us out? Winnow down your request to be more specific."
Thank you. And I guess just in trying to get a little more finality here on what we're talking about, and I do have a couple of things that I think would improve the quality of the bill. once we adopt the committee report, that I think we may have a couple of amendments that would be coming. But again, we're saying this is not going to restrict the ability of the federal government to come and be able to get folks who are slated for deportation because they're here illegally and they've also committed additional crimes. But it's still saying that they can't. I guess I don't understand. If you're trying to enforce federal immigration law and you're the federal government, I get list brokers. I get why we would want to restrict people who are just trying to go grab information. But I guess I don't quite understand why there's between law enforcement agencies in the state and state government and the federal government, why there's not a very robust flow of information already, considering the economic situation we're in, the amount of money we spend, the state taxpayers spend on folks who are here illegally. Why is there not already a robust flow of information that would be outside of this bill? Or are you telling me it is outside of this bill?
No, I think, well, I mean, and the senator I know from Howard County wants to get in on this because we had a data privacy bill, I think 2 years ago or last year maybe, and the senator can certainly speak to that and the importance of this. But what we're talking about is, think about large swaths of your personal data being sucked up and then being sent to a third party and then being sent to the government. This is private information that I don't think we want out on the marketplace that can just be shipped off to anyone with financial ability to pay for that information that's been packaged. So I would, Mr. President,
Senator wishes to yield to the senator from District 9. Senator may proceed.
Thank you, Mr. President, and thank you, Chair. We actually called JPR a couple times during the lunch break and couldn't get through because we're all working so hard. So I have a couple of questions that aren't.
Senator, I'm sorry. I thought that the minority whip still has the floor.
Oh.
I do, although I would not mind yielding. Maybe one follow-up, and it might set up the question for the senator from. I'll yield. I'd like to hear, because I'm curious about this issue of personal data and what this bill does for everybody, not just one particular group. So I'd be happy to yield to the senator from District 9.
Excellent. Okay. Senator from District 9 has questions for the floor leader. Senator may proceed.
Thank you very much, and thank you for our quick conversation earlier. So I'm just trying to figure out how this bill fits with the online data privacy bill, which will go into effect later this year, and whether or not, like, the people that we're talking about, on, I guess, the first page C, of this bill, like, won't they also be covered by the Maryland online data privacy bill?
I tried to get an answer to that from counsel, and since the way that it's drafted, it's everybody, right? So it's not at that portion, so it's all people's PII within government database. If there is overlap there, then the answer is yes. I'm not quite sure that's the case.
I mean, so I really hope that in general, the state government is not, giving away data broadly, because I have so many concerns with this. I mean, what about our health data? What about our Medicaid benefits data? What about our location data? With the power of artificial intelligence, like, growing exponentially, there is nothing that would prevent. In fact, there are signs that this administration is using artificial intelligence to mix and match all these personal data points and make decisions about our benefits. It just is a really scary time. So I guess my first question is to try to figure out whether or not this is all covered underneath the Maryland data privacy bill. And then secondly, could we possibly just, like, broaden this so that it's not just this one type of data we're looking for, but other kinds of data that should be shielded, from public consumption?
So actually, I thank you for bringing that up, and the way that it's drafted actually does cover that information. And so for the first part, for the government to the private sector, so under subsection C, that's exactly right. It's all of that government information, that PII. And I think the senator from District 16 we're talking about this when we voted on this earlier today. We were talking about that. We didn't quite get into that level of discussion, but that's exactly it. It's all of that information that's within a government database, and so you're absolutely right. So this does cover it. We were talking about an amendment to winnow that down to just for immigration enforcement for this part one of that piece, but this is protective of all of that information as drafted.
Okay, well then if we'd have time, I would consider an amendment that would prevent this data from being compiled and used in the furtherance of decisions that produce legal effects, consider, that might influence consequential decisions, whether it's, mortgages or government benefits or any different types of things. I mean, I really feel like there should be like a human in the loop before we go forward with any of this information.
So, I appreciate that, and I do think that's covered under this, but if not, we should work on that further, and I'm willing to have that discussion, but I would like to keep this in a relatively clean posture at the moment. But I do think that that's covered, but I do think the conversation you're talking about is very important because we do need to be protective of our personal data that's housed within our government databases.
All right, question remains on the two committee amendments. Are there any senators who have not yet spoken who wish to speak? If not, recognize the minority whip.
Thank you, Mr. President. Now I'll conclude questioning with this line here of questioning. But, Mr. Chairman, so I feel like this conversation about consumer data is getting us, it's interesting, but it's getting us, I think, a little far afield of the bill. I only say that because, like, ICE has major concerns about this bill. The ICE director came and testified in your committee that this was something that they're watching closely. They're very concerned about it for a number of reasons that I won't necessarily repeat all the way through, but essentially going to dramatically restrict ability to deport, yes, dangerous illegal immigrants. So what has been done to the bill to assuage those concerns?
We've actually been attempting to loop back with them since we had that initial conversation and have been unsuccessful, but we're going to continue that conversation. On page 4 of the bill, from line 7 to 32, that was the genesis of the concern, because it would say that a law enforcement agency or a unit of state government operating in a building or facility shall deny access to the building or facility to any individual who appears to be seeking access for the purpose. That's out. So that was the genesis of their very very vigorous opposition to this bill as initially drafted.
Okay. Thank you. Mr. President, there may be a couple of, as I said, ideas to improve this bill. But my questions are done. Thank you.
All right, question on the two committee amendments, on the amendments. Any further discussion on the amendments? Any objection to the amendments? Without objection, the two committee amendments are adopted. Question now is on the amended report. Any discussion on the report? Any objections to the amended report? Without objection, the amended report is adopted. Recognize the minority whip has an amendment. All right. Pages will collect and distribute the senator's amendment. Senator may explain the amendment.
Thank you, Mr. President. And actually understanding some of the nature of the concern about scraping data or PIA of data, I think this amendment actually will be very appropriate because it should avoid that problem of opening it up too much. I don't believe people can file PIA information on who's in a federal facility, but maybe I'll be told otherwise. But this amendment, Mr. President, I think it's just very important to leave no doubt that our federal immigration enforcement folks can cooperate, and that our local jails facilities and our state facilities are able to cooperate with ICE in an important work of folks who are here. We know there's a lot of diversity of opinions about illegal immigration overall. I think most people in America don't have a problem with overall immigration, and I think there's a lot of consensus around the idea that if you can secure the border and really get a handle on some of the worst of the illegal immigration, that there's an opportunity to find a way to deal with folks who've been here for a long time. Even President Trump, that was kind of his position in his first term. All he wanted was a wall, and he was, give me a wall, we'll find a path to citizenship. And it was $10 billion was just too much, I guess, for a wall in a multi-trillion-dollar federal budget. But anyway, this amendment, what it would do would say that we're saying state and local correctional facilities shouldn't be a part of this. So that this paragraph does not apply to a state or local correctional facility in possession of personal information of an individual who is in the custody of the state or local correctional facility. So that's what the amendment does. It's just simply, and the term database does not include a database operated by a state or local correctional facility. I think it'd be a good common sense way to be sure there's no confusion that places that have our incarcerated individuals can cooperate fully with federal immigration authorities. And I would move the amendment, Mr. President.
All right, Senator moves the amendment. Let's hear from the floor leader.
Thank you, Mr. President. I would say that the amendment's not really necessary, and I would ask the body to reject it. First, because if you have that judicial warrant, if someone is suspected of criminal activity, and you've met that burden, that applies to anyone who's incarcerated in a prison or a correctional facility. So you don't really need that. But this also applies to everyone, not just people for immigration enforcement. Second, and this is on another end of the extreme, we had a bill and we entertained, and we're going to work on it on the interim, about commissioner complaints or citizen complaints. People can go to a commissioner and file a complaint, and then an arrest warrant can be issued on that allegation. So one person can go ahead and do that. And we had testimony in the committee that the person never saw a judge, the person saw a commissioner, the person spent days in jail, and there was the allegations were unfounded ultimately. And so you're gonna to have people can get incarcerated for a multitude of different reasons, a number of which are unfounded allegations. Those are possibilities. So because if you have a judicial warrant, if someone's dangerous and you got a warrant, that applies to the correctional facilities. You can get in there, you can get all that information. And because there are some extreme instances in which you don't even need a judge to have someone incarcerated, I would ask that the body reject this amendment.
On the amendment, are there any senators who have not yet spoken who wish to speak? If not, maker of the amendment.
Thank you, Mr. President. Yeah, I would just press the amendment and ask for a roll call. I think it's there may be a few cases that are being talked about that the Judicial Proceedings Committee, I'm sure, will work on next year. But overall, what's happening is if someone is in a state correctional facility or a county jail, and we want to be sure that if they're serving time in that facility, we want to be sure that if they are here illegally in this country and have committed an additional crime, that there's no barrier between communication about that. And they obviously had a warrant to get them into the jail anyway to serve time. So I would just say, I would ask the body to join me in support and make sure we don't, maybe throw the baby out with the bathwater as it relates to maybe trying to crack down some other bad practices. Let's be sure we keep that very important relationship alive. So I would ask for the body's green vote on that amendment.
All right, Senator moves the amendment.
Just very succinctly for the record, I mean, like if you have the warrant to be incarcerated, then they can share the information under this bill. So just
excellent
clarifying that.
Thank you, Mr. Chair. All right, on the amendment, the clerk will call the roll.
Mr. President.
Has everyone recorded their vote? Anyone wish to change their vote? Explain their vote? If not, the clerk will take the call. 28 votes to the negative, the senator's amendment fails. There are further amendments to the bill or its title. Recognized senator from District 37 has an amendment.
Thank you, Mr. President. I have an amendment at the desk.
All right, pages will collect and distribute the senator's amendment.
That's the one. Yep.
No, trying to get it. I think we're having a printer ink issue. There we go. Senator may explain the amendment.
Thank you, Mr. President. Colleagues, what this amendment does is it simply carves out anyone covered with a record of, it reads, covered record of a person who has been convicted of a crime of violence, defined in 14-101 of the criminal law article. So if you've been convicted of a crime of violence, it would exempt you from the protections that are created by the legislation. And as we heard earlier in the discussion about data and the transactions and what's going on, you can go online and check a record if there's an individual of interest. However, you can't find out where that individual is housed if that's an individual of interest that ICE would like to go, detain. And if it's someone that's, in consideration for immigration proceedings. So this would carve out that selected class of individuals who are the top priority of concern for public safety. Those are the individuals who are convicted of a crime of violence. Don't worry, I am not going to ask the floor leader to tell us what every act of a crime of violence is. We're not going to do that today. But this is a very serious amendment, and I don't mean to inflict humility to undermine the importance of the amendment. I just this past weekend was home, and we dealt with an immigration issue a couple of years ago dealing with correctional facilities, and I voted against it, and it was a priority, and that was dealt with contracts and local facilities and holding individuals. And it was a family, and their family member had been sent to another state because they couldn't be held in Maryland, and that's a different discussion for a different day. This is a here and now consideration. We're talking about the most dangerous of dangerous, people that have been convicted of a crime of violence. There is a need to be able to find out where they are. I don't understand or see the need to create a special protection, and I would move the amendment, and I'd ask for a recorded vote, Mr. President.
All right, Senator moves the amendment. Let's hear from the floor leader.
Thank you very much, Mr. President. And I thank the senator for not having me enumerate all the crimes of violence. I appreciate that one. But look, if you are convicted of a 14101 or a crime of violence, you're most likely going to be sentenced to a term of more than 18 months, which means you're going to be removed to a prison, not a detention center. But while you're in that detention center, that local jurisdiction has the option, and even in Montgomery County, as I have mentioned, which is most would consider to be one of the more progressive counties or the most progressive county, my county is cooperating with folks that have been charged and who are incarcerated for those violent crimes, and is cooperating now without a 287G program. Then we were talking about there are more 287G programs coming online as we speak. So this bill doesn't cover that because the jurisdictions have the ability to share that and are doing it and are sharing that information of incarcerated individuals. And once they have paid their debt to society under our current law, then they will release them into the custody of a ICE official. So that's happening. This bill doesn't touch that. That information is being shared, whether you're in a prison or a local detention facility. So I would ask the body to reject that amendment because you're going to be incarcerated. It's in all of our interest to have anyone that violates the law, regardless of their immigration status, to pay their debt to society. And then our counties are already cooperating and sharing that information. This bill does not touch that.
Well, I appreciate that, and I think the fact that there's already a shown interest in making sure that individuals who are convicted of a crime of violence are treated differently, I think that speaks for itself. With regards to this legislation affecting the way they're treated, well, who says that the immigration enforcement wants to wait until they finish their term? Perhaps they want to come get them sooner. In addition, we're putting this bill, or this proposal would put new protections in law. So why would we include these individuals in those protections if already our most progressive counties, if that's the way to, I don't want to offend anybody, that's the way it was mentioned, if that's the way it's being done already, then why wait? Why wait and just let's move along with the common practice and include this amendment that would say, if you're convicted of a crime of violence, you would not be protected by this law. It's already being done.
Again, like I said, in the interest of public safety, all of the counties that I'm aware of are cooperating in that respect, but are also holding folks accountable. So if you are convicted of a crime of violence, you're going to do your time in a Maryland facility. And if DHS wants to come and get that person early, which is their prerogative, like I said, the jurisdictions that I'm aware of that don't even have the 287G program are still cooperating in that fashion in the interest of public safety.
And correct me if I'm wrong, but the sharing of data is the one standard that ICE uses to determine whether a state is designated as a sanctuary state. And of all the individuals that ICE would be interested in, it would be those that have been convicted of crimes of violence. So to even roll the dice to find out how that plays, everybody should be aware that that should be a factor taken into consideration when moving forward, either voting for or against this amendment.
Just to be, Mr. President, just to be clear, look, if someone's incarcerated, there's nothing in this bill that prevents the local jurisdiction from communicating with immigration enforcement. There's nothing in the bill that prevents them from doing that under this bill if the local law enforcement wants to do that. So just to be clear on that, we may have that conversation a little later on, but that's not this bill.
Well, with that, Mr. President, I'd like to press the amendment and request a recorded vote.
All right, on the amendment, any further discussion? If not, clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 26 votes in the negative, the senator's amendment fails. Are there further amendments to the bill or title? Recognized senator from the 37th has an amendment.
Thank you, Mr. President. I have one more amendment at the desk.
All right, well, not quite at the desk yet. It is
Oh.
on its way, traveling to the desk in just a moment. To the wonderful Rochelle who's helping us.
Oh, can I have one more?
Our page clerk has been
Seatmate, that's it. That's it.
helping our page program this year. We appreciate her work and helping leading our young people have a great year. Thank you. All right, Senator may explain the amendment.
Thank you, Mr. President. Colleagues, I don't need to go through a whole lot because this is very similar to the amendment we just debated. However, it's a little more refined. Crimes of violence is a long list, and this amendment would exclude, it would not be crimes of violence. It would be limited to individuals convicted of Title IX, subsection 8, which is criminal organizations. And to surmise that, it would be gang activity. That is a specific conviction. There are many cases, criminal cases, where there is criminal organization activities, not necessarily always prosecuted. It's safe to assume that the most egregious cases would be those that would include all the charges, such as the criminal organization charges contained in Title IX, Subtitle 8. Again, you've heard the arguments back and forth. This is a more refined approach, targeting those individuals that we know very well and clear that are of the utmost highest priority of our federal immigration enforcement officials right now. So with that, I would press the amendment, Mr. President, and I'll ask for a recorded vote, but I'll follow up again.
All right, the senator moves the amendment. Let's check with the floor leader here.
Thank you very much, Mr. President. Again, for the reason, the same arguments apply to this as the last amendment. Look, if you are convicted, that information is available to federal law enforcement agencies. If you're sitting in a jail cell, either in a prison or in a correctional facility, that information is available, and our cooperation with the federal law enforcement is not impeded in any way from this bill if someone is sitting convicted of a crime of violence or an association or affiliation with gang activity. So this is not an amendment that's necessary. We are cooperating in the interest of public safety, and we will continue to do that in Maryland.
So the bill,
Sorry, Senator has not yet spoken. Recognize the minority whip.
Thank you, Mr. President. In support of my colleague's amendment, I think it's really important that we understand that the bills that we pass really matter in the broader scope. And I've got an article here from March 3rd of 2025 from Baltimore, that U.S. Immigration and Customs Enforcement and the FBI apprehended an illegal Salvadoran alien charged in his home country with the possession of firearm, extortion, and terrorist affiliation when officers had arrested him, David Oriano Alaman, in Hyattsville on February 27th. The apprehension of this person strikes a significant blow to the leadership and organization of MS-13, said ICE Enforcement and Removal Operations Acting Field Director Matthew Elston. This arrest speaks volume about the cooperation enjoyed between ICE and the FBI. We will continue to prioritize public safety by arresting and removing illegal alien offenders from our communities. Oriana is a high-ranking leader in the MS-13 transnational terrorist organization, which operates extensively in Maryland and has for quite some time, and controlled the operation of MS-13 cliques in the United States, Mexico, and Europe. Maryland is immediately safer because of this arrest. Working together, we took custody of one of the highest-ranking gang members in the United States, said FBI Baltimore Special Agent in Charge William Dabano. He is no longer in his alleged position of power, directing violence. And the quote goes on. Authorities in El Salvador had arrested Oriana December 1st of 2016 and charged him for possession of a firearm, extortion, and terrorist affiliation as a documented member of MS-13. The Prince George's County Police Department arrested him on December 9th of 2024, charged him for driving without a license. Imagine if it was unclear in state law that data could be shared between law enforcement agencies in a county in Maryland and ICE and the FBI. Imagine if, as the bill talks about, things had to be very specific with what data was passed back and forth and what information was gathered, or that the record to be accessed had to be clearly identified, or there was all these details, and you had this dangerous criminal, yes, illegal immigrant who should never be in this country, and we can't share information. Now, I know the response to my assertion here will be, no, this bill's not doing that, or that's a different bill, or we struck a lot of that out. I think we should be absolutely certain, and the gentleman's amendment does this, that if you are someone who's been convicted of this kind of gang activity, this guy hasn't even been convicted yet, but there are people who were convicted of gang activity that could be eligible for deportation once they finish their sentence. We ought to be sure that that's not allowed, that we don't get in the way of that. So I support the amendment, and my vote will be green.
All right. On the amendment, are there any senators who have not yet spoken who wish to speak? If not, we can go back to the maker of the amendment.
Thank you, Mr. President. Just to look at the DLS fiscal report, it says a law enforcement agency or a unit of state government or local government operating a database must deny access to the database to any individual who is or appears to be seeking access for the purpose of enforcing federal immigration law, unless the individual presents a valid warrant issued by a federal court or a court of this state and clearly identifies the record to be accessed. Who seeking access for the purpose of enforcing federal immigration law. This is not a random inquiry. It's not someone off the street. This is not a data scammer trying to collect information on people. It is very specific where the request is coming from and what the purpose of the request is for. Again, this is a very targeted, narrow group of individuals. It's Title 9, subsection 8, criminal organizations. You heard some of the names of these organizations, some of the most notoriously heinous, dangerous, here in Maryland. Why would we ever want to protect their data from immigration enforcement? The most dangerous, wanted knowingly, people here I'm a Christian, I'm a believer, everyone is God's creation, but nothing in that says that your data should be protected. They're convicted under the criminal organizations. This is not like the standard conviction. This is one of the highest standards. There's nothing unethical or immoral about saying these individuals shouldn't get special data protection privileges for this specific purpose. Our own fiscal note says right there what it's for. Either we're recognizing this or ignoring it. And I hate to see everyone get pinched in a box over this decision because we have to put our name and a vote up on that board, because it shouldn't be a pressure situation. I think it's a really easy call if you're at the neighborhood convenience store and you're confronted with a situation and said, how in the world did this ever happen in my neighborhood? You know, how did this happen to my family members? How did this happen to the place I grew up in? Because we've let it happen. Look, this amendment doesn't make that go away at all. There's nothing in the amendment that solves that problem, but certainly allowing the bill to go forward and ignoring this straightforward, exception is definitely showing an acknowledgement and recognition. One of the biggest parts of fixing a problem, the hardest part of fixing a problem, is looking in the mirror and realizing it. I do it every morning, colleagues. I look in the mirror and I say, you're the problem. And then I go to work. How do I be a better person? Well, don't get lost in the national debate over immigration. This is a very simple thing where we look at our own communities, how it affects our districts. Think about the problems that we have to fix. How is it going to fix our state? What are we doing to make our state better? What is the biggest threat to our public safety? It's gang violence. It's the most heinous, most dangerous thing out there. And I can't speak to it because I'm not an expert, but gosh forbid the kids that grow up around it, and the families that are affected by that. So with that, I'm going to come off my soapbox. I think this is it's a great idea. I think it sends the right message. I think it's on par with what so many people in our districts would like to see. I'd press for a roll call vote, Mr. President, and I thank everybody for the indulgence.
All right, the senator moves on the amendment. Any further discussion? Yes, recognize the senator from the 38th district on the amendment.
Thank you, Mr. President. On the amendment, I rise in strong support of this amendment. It's about public safety. It's what our constituents expect, that we have an opportunity to cast this vote for public safety, to protect our constituents. It's common sense, and I would urge my colleagues to cast a yay vote.
All right, thank you, Senator. All right, any further discussion of the amendment? If not, clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote? Explain their vote. If not, the clerk will take the call. With 24 votes in the negative, the senator's amendment fails. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 977 is hereby ordered printed for third reading. All right, let's see. We've got a second reading bill here. Committee on Education, Energy, and the Environment. Clerk will read the bill. Report 24.
Senate Bill 425, Senator Jackson, Environment, Coal Combustible Byproducts, Fees, Coordinating Committee, and Regulations, favorable with 2 amendments.
All right, recognizing Senator from District 9 as the floor leader.
Thank you, Mr. President. Colleagues, as amended, Senate Bill 425 alters the factors that the Maryland Department of the Environment must consider when setting the coal combustion byproduct fee, which is consistent now with the provisions of Senate Bill 250. The bill also establishes the statewide coal combustion byproduct coordinating committee, requires the department to adopt regulations incorporating the bill's provisions and adopting the U.S. EPA's final rule governing legacy coal combustion residuals. There are 2 committee amendments. The first one is technical, and the second one strikes language that would have set a floor on the coal combustion byproduct fee and alters requirements for regulations adopted under the bill. The amendment also requires the department to use any fee revenue that exceeds the amount necessary to operate its regulatory program to increase the beneficial reuse of coal combustion byproducts and mitigate certain health and environmental impacts due to the release of coal combustion byproducts from priority sites. I move the 2 committee amendments and the favorable committee report.
Floor leader moves to the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Yes, recognizing the minority leader on the amendments.
Thank you, Mr. President. If the floor leader would yield,
Floor to yield.
please.
Senator may proceed.
Thank you very much. Just, can you go back over this amendment that took out the floor for the price per ton that was currently
Yes,
was
so that
in
is on
place?
page 2, lines 1 through 6, and that is because that language was, I think, moved into Senate Bill 250, so this bill is now consistent with Senate Bill 250.
This language, so it's just out of this bill, but it is somewhere else. Is that what you're saying?
I believe it's in Senate Bill 250, yes.
In Senate Bill 250.
Oh,
Is that right?
never mind, it's not. No, that was current law, and we took it out.
So current law just says that they can charge a fee on a per ton basis for coal combustion byproducts. The language as the bill was submitted put a floor in there and said it may not be less than 230, but that was struck out through the committee amendments, right?
Correct.
Okay, so currently then, what is the fee that can be charged?
So there is no fee currently in this bill. If you bear with me, I will tell you. Call April on 546.
I can't read this.
I'm just a slight delay because that bill is not before us right now. That was in Senate Bill
Oh,
250.
I
Stand
didn't know that.
by.
Look at that. Isn't that neat? I appreciate that.
It wasn't in two. The current fee is $80 per ton.
So the current fee is 80 per ton. This bill was going to say that it could not be less than $2.30 per ton? Is that accurate? It's quite a difference.
Sorry, there's a couple different. I've learned a lot more about coal byproducts than I ever wanted to know. And it's still not enough. Hold on.
Okay.
So,
So
okay, so the $80 was for the old coal fee. There is a new fee being set for the ash that is disposed of, either in a landfill or on site in some places. And so once it's disposed of, there will be a new fee. And that fee is the $2.30.
Okay, that fee was going to be $2, not less than $2.30, but it was taken out of the bill. It was amended out.
Correct.
So I guess that's the question.
So this bill is silent on the fee.
That's what I was wondering. So there's nothing in this bill or current language that says what the per ton rate is. So has the Department of Environment already established that through regulations or something else? I mean, I'm wondering why the 230, why it was thought to put the $2.30 in the bill to begin with. And if that was the floor, it couldn't be less than that.
So-
why that was taken out of the bill, and what are we relying on it to be now from the Department of Environment?
So my understanding is that that is in Senate Bill 250, and I do not have that in front of me.
Okay.
This bill that we're talking about is a work group bill, and it's a really great work group bill that's going to look at exactly where we need to be monitoring and measuring this byproduct, which is in the ground, and what it's doing to our water and other environmental attributes going forward.
Right. So outside of what the fee is, this sets up the new commission, correct?
Correct.
And it goes through this coordinating committee and talks about a little bit of how it's set up and then what it's aimed to look at. The question was, have these these byproducts have ended up in landfills, and that's what it's going to look at as well too, correct?
Correct.
And in ending up in landfills, obviously it was previously allowed to go into landfills. Is this committee going to address whether or not it can go into landfills in the future, or if there has to be another way of disposition?
I think the bill states that for the coal combustion byproducts sites, it's going to share the information and the monitoring results and discuss remedial action that is currently in process, that is still required, or both.
Or both, okay.
And
So-
how do we clean it up?
Right, so do we know in Maryland, for instance, how many, I'm trying to get to the same type of thing, one who's paying the fees, and then how many facilities are affected by this? Do we know that? Is there anything else? Anything else here for me?
Okay, there are 3 regulated coal ash landfills
Okay,
and 18 coal ash legacy ponds and inactive landfills.
okay. So the commission will, according to this, will study that and then possibly give recommendations for some type of remedial action to that?
Yes.
And do we know from the testimony in committee what those types of remedial actions could be? Were they discussed at all by Department of Environment? I don't know.
I don't believe the Department of the Environment actually submitted testimony on this particular bill because they were focused on Senate Bill 250.
Okay. And the generation of coal ash is from coal-fire electric generating facilities?
Yes.
And so as the movement has been to decrease those within the state, is the thought focused more on new ash that's generated or existing ash that's already in facilities?
Existing.
Okay, so that's what I'm trying to, okay, so you're saying that this has no fees attached to it, other than what the Department of Environment is potentially already,
Senate Bill 425 has no fees in it anymore,
no fees anymore, no
No.
new fees. But Senate Bill 250.
but that has been passed and is no longer in front of us.
Right, okay, so we can take a look at Senate Bill 250,
I
so.
think we've already voted it.
Yep, but we can still look at it. So, Mr. President, would I be able to lay over the bill and the amendments under the rule, please?
The senator's motion is in order, would have been especially in order several minutes ago.
This is a
but
work
regardless,
group bill.
The bill, it's a motion, it's a motion. The bill and the amendment will lie over under the rule, still in order. All right, we're going to try and do this quickly. We got, let's do, if we could ring the bells, Madam Secretary, and if we could do a quorum call.
Mr. President,
Has everyone recorded their presence? If so, the clerk will take the call. Oh, sorry. Sorry about that. We got you. All right, with 44 members in the chamber and a quorum being present, the Senate of Maryland remains in session.
Mr. President, could I just take a moment to recognize our Doctor of the Day?
Sure, Senator,
Thank
may
you.
proceed.
Doctor of the Day is Padmini Rashin from our 43rd District, and she is, we see her often, she's the president of MedChi, and it's with Johns Hopkins Hospital. Please give her a warm Senate welcome. Thank you.
Welcome. We believe your kids were here watching today, yes? Very good, very good. Welcome. We're glad they could join us. We lost them, but we'll see where they're traveling somewhere. Excellent. All right, let's go ahead and get through. This is calendar number 50. Calendar number 50. Clerk, read the first bill.
Senate Bill 127, Senator Kagan, State Government Grants and Contracts Reimbursement of Indirect Costs.
Senate Bill 127 is on third reading, final passage. Any discussion? If not, clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 44 votes in the affirmative, Senate Bill 127, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 270, Senator M. Jackson, Board of Trustees of the Maryland Teachers and State Employees Supplemental Retirement Plan, Automatic Enrollment.
Senate Bill 270 is on third reading, final passage. Any discussion? If not, clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 44 votes in the affirmative, Senate Bill 270, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 376, Senator Kramer, Health Facilities Delegation of Inspection Authority, Nursing Homes.
Senate Bill 376 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 44 votes in the affirmative, Senate Bill 376, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 449, Frederick County Senators, Frederick and Washington Counties bow hunting, openly carrying handguns.
Senate Bill 449 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 44 votes in the affirmative, Senate Bill 449, having received a constitutional majority, is declared passed. Clerk, read the next bill.
Senate Bill 599, Senator Heddleman, Behavioral Health Crisis Response Grant Program funding.
Senate Bill 599 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 31 votes in the affirmative, Senate Bill 599, having received a constitutional majority, is declared passed. Clerk, read the next bill.
Senate Bill 814, Senator Watson, Local Government Development Impact Fees, Surcharges, and Excise Taxes reporting.
Senate Bill 814 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 44 votes in the affirmative, Senate Bill 814, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 854, Senator Lewis Young, Health Occupations License Direct Entry Midwives revisions.
Senate Bill 854 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 44 votes in the affirmative, Senate Bill 854 having
94, Senator M. Washington, Office of Social Equity, Community Reinvestment and Repair Fund modifications.
Senate Bill 894 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk
will take the call. With 30 votes in the affirmative, Senate Bill 894, having received a constitutional majority, is declared passed. Clerk, read the next bill.
Senate Bill 962, Senator Mounts, Municipalities Legislative Audit Exemption.
Senate Bill 962 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote? Explain their vote. If so, the clerk will take the call. With 45 votes in the affirmative, Senate Bill 962, having received a constitutional majority, is declared passed. Clerk, read the next bill.
Senate Bill 1021, Senator C. Jackson, Business Regulations, Cemeteries, Requirements for Sale or Transfer or Government Acquisition.
Senate Bill 1021 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote? Explain their vote? If not, the clerk will take the call. With 44 votes in the affirmative, Senate Bill 1021, having received a constitutional majority, is declared passed. All right, that does it. Desk is, oh, just kidding, hold. Oh, great, okay. Appears we have a motion to reconsider the vote by which a special order was approved. Recognize the minority leader on that. Is that the motion?
Motion to reconsider the vote on which a special order was originally approved.
All right, any objections to the motion? Without objection, the motion passes and the bill is back before the Senate. If we could have the clerk read the bill.
Senate Bill 843, Senator Hershey, School Construction Low-Cost Share Alterations, Questions, and the Adoption of the two committee amendments and the favorable report.
All right, questions on the two committee amendments. The senator has, are these substitute amendments or additional amendments?
It's a good question as to how it's drafted. Substitute.
Substitute, okay, so does the senator move to withdraw the committee amendments by which, withdraw the committee amendments?
Yes.
All right, committee amendments, are any objection? Without objection, the committee amendments are withdrawn. The senator has now put forward substitute amendments. Let's see here. The motion to withdraw is accepted. Yep, there we go. Substitute amendments. All right, if the senator would like to explain the substitute amendment.
Sure, absolutely. As I mentioned, the amendments in committee were designed to deal with the cost per student of building this new school. The county would like to have a bigger state share. They're a small district. It's a small school. There's a great need. The original amendments basically had a sliding scale for what the cost per student could be to get the additional state help. This changes it to make it a flat amount of $129,000 per student. And if it's below that number, they get the additional state help. If it's more than that, they don't. And it's been worked out with the sponsor of the bill.
All right.
Thank you.
Senator moves the amendment and the favorable committee report. Hear from the sponsor on the committee amendment.
Yeah, thank you very much, Mr. President. And thank you to the floor leader and the chair of the committee for working with us on this very important issue in Kent County.
All right. Question remains on the committee amendment. Any discussion? Recognized senator from the 20th district.
Yeah, thank you, Mr. President. Question for the floor leader.
For the floor leader on the amendment. Senator,
Sure.
proceed.
Okay, well, could I just talk about the bill in general? I'm not sure if this is a local bill. Does it affect
It only
all
affects
small
Kent County.
counties? Oh,
It
just
only
one?
affects Kent County.
Okay, just one. Okay, great. Thank you. Thank you.
All right. Thank you. On the committee amendment, any further discussion? Any objections to the committee amendment? Without objection, the committee amendment is adopted. Question now on the amended report. Any discussion? Any objection? Without objection, the amended report is adopted. Are there further amendments to the bill or its title? Seeing none, Senate Bill 843 is hereby ordered printed for third reading. All right, desk is clear. Desk is clear. We're gonna have I don't think we're gonna be too late tonight, so I think we should be. We're still gonna go for 8 o'clock. We have some guests, so we're gonna shoot for 8, but shouldn't be too long. Knock on wood. We'll see. It's bringing jinxing ourselves. Let's see. Finance, Tripoli, Budget and Tax, JPR, other standing committees, executive noms at coming at 5. Right away, chairs of executive nominations.
Sure. Executive nominations is meeting in 4 minutes in the Amos hearing room.
Head on over. Sprint. Race to the top. All right. Any Other announcements before we adjourn? Senator from the 23rd? Nope. Okay. All right. That does. Let's do a quorum call.
Mr. President,
Has everyone recorded their presence? If so, the clerk will take the call. With 45 members in the chamber and a quorum being present, Senate of Maryland remains in session. Recognize the Majority Leader.
Thank you, Mr. President. I move the Senate of Maryland stand adjourned until 8:00 p.m. this evening.
Excellent. Without objection, so ordered. Stay safe, everyone. Good work today. See you tonight.